All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer les fonctions résiduelles de tribunaux pénaux est ouverte. Please be seated.
Well, good morning to everyone. We will continue with the hearing. And first of all, I want to know if Mr. Stanišić and Mr. Simatović can hear us in a language they can understand. So I will make that question to each one of them. Mr. Stanišić, can you hear the proceedings in a language that you can understand? Please turn on the microphone because we couldn't hear.
Sorry. Da,
Yes, Your Honor.
Much. Mr. Simatović, can you hear the proceedings in a language that you can understand?
Yes, Your Honor.
Thank you very much. So now we will continue with the appearances of the parties. Prosecution.
Good morning, Your Honors. Laurel Begg for the prosecution, joined by my colleagues Grace Harbour and Lorna Bolton, our case manager Janet Stewart, and Ms. Christine Keller. And yesterday we were also joined, and I'd like to mention this for the record, by Sarah Horan, Alison de Brewer, and Rafael Braga da Silva.
Thank you very much. Counsel for Mr. Stanišić.
Good morning, Your Honor. For Mr. Stanišić, myself, Wayne Jordash, Joe Holmes, Ruby Axelson, Prashiti Venkrantaman, and Maria Teresa Kokach.
Thank you very much. Counsel for Mr. Simatović.
Good morning, Your Honor. Good morning to everyone in and around the courtroom. On behalf of Mr. Simatović, as yesterday, today we have Vladimir Petrović and myself, Mihailo Bakrać.
And we shall now continue the hearing, beginning with the prosecution's submissions. So, counsel, you have 1 hour for this part of the session.
Thank you, Your Honors. From 1991 to 1995, Stanišić and Simatović were senior members of the Serbian State Security Service. And the evidence demonstrated that time and again, over a nearly 5-year period, Stanišić and Simatović used state security resources, including their own elite combat unit that you heard about yesterday, to assist other Serb forces involved in ethnic cleansing operations, advancing the common criminal plan of forcing non-Serbs from large areas of Croatia and Bosnia-Herzegovina. Despite the breadth and frequency of their contributions, Stanišić and Simatović were convicted of aiding and abetting the crimes of murder, persecution, deportation, and forcible transfer in only one municipality, Bosanski Shamac. But for the errors identified in the prosecution's appeal, Stanišić and Simatović would have been convicted for their participation in a much broader range of crimes. Today, Your Honors, I'll focus on 3 main topics. First, the trial chamber's failure to assess the totality of Stanišić and Simatović's contributions to the common criminal plan. This is ground 1A of our appeal. And once I have explained the legal errors, I'll move to Your Honor's questions regarding the JCE aspects. And this will be the longest part of my submissions. And then, second, the trial chamber's errors in assessing the criminal responsibility for aiding and abetting, where it focused on only one municipality, ignoring its own findings of Stanišić and Simatović's involvement in crimes in other places. This is ground 2, and here I will address the aiding and abetting aspects of your questions. And third, I will deal with the trial chamber's errors in assessing intent. The chamber ignored relevant findings and evidence and misapplied the beyond reasonable doubt standard. This is ground 1B. I do not intend to address ground 1C and 2C. I only wish to clarify that the prosecution is still seeking declaratory relief. We're asking the appeals chamber to confirm that the trial chamber overstepped when it adopted an unnecessary and disproportionate procedure that interfered in prosecutorial discretion. And this is still important for the mechanism's legacy because our precedents are followed by other international courts. So let me begin with the chamber's errors in assessing the contribution required for joint criminal enterprise. In my oral submissions, I'm going to focus on the 2 legal sub-errors that are most closely linked to Your Honor's questions. I'll start with the chamber's application of the wrong legal standard. This is sub-ground 1A1. Your Honors, the law regarding JCE contributions is settled. In the Mladić appeals judgment, the mechanism reconfirmed again that contributions are defined as any conduct furthering the common plan or purpose of the joint criminal enterprise. That's paragraph 179. And this is why the appeals chamber in the ICTY, in this case, found at paragraph 82 that a trial chamber must first determine the existence and scope of the common criminal plan in order to then adjudicate whether the accused conduct furthers that plan. And the retrial chamber began at the right spot. It started by determining the existence and scope of the joint criminal enterprise. It found at paragraph 379 that at least by August 1991, a common criminal plan existed to forcibly and permanently remove non-Serbs from large areas of Croatia and Bosnia-Herzegovina through the commission of the crimes of persecution, murder, deportation, and forcible transfer. And this plan encompassed, but was not limited to, the specific criminal incidents charged in the indictment. And it's this plan that should have been the point of reference for assessing whether the conduct could be counted as a contribution. The chamber should have asked, did the accused conduct further this plan? But instead of applying the settled law, the retrial chamber systematically refused to count any contribution unless it was directly related to or linked to specific charged criminal incidents. And this is simply too narrow of a test. And this legal error is at the root of the chamber's disregard of Stanišić and Simatović's many contributions to the criminal plan. And we've set these out in our brief. The law is clear that conduct can advance the common criminal plan without being directly linked to a charged crime or criminal incident. Let me be very, very clear. Convictions may only be entered for the specific criminal incidents charged in the indictment. And we often call this the crime base. But an accused criminal responsibility for a crime-based incident can come from more than direct contribution to that specific criminal incident. A person can be held criminally responsible for a crime-based incident as a member of a joint criminal enterprise for making a specific contribution in furtherance of a shared common criminal plan. This distinction might not have any impact in cases involving a common criminal purpose that is coextensive with the crime base. And this explains why we sometimes see references in our case law to a contribution to the crime or crimes. But the case law is clear that the focus of the test for a contribution is whether it furthers the common criminal plan, not whether it contributes directly to an individual crime. The ICTR Appeals Chamber rejected Ngirapatse's argument that JCE contributions must be linked to a specific crime. And I'm going to ask for a slide here with a quotation from that case, and this can be projected to the public. The ICTR Appeals Chamber it explained that the trial chamber was, quote, not required to find that Ngirapatse contributed to each criminal act, but rather that he made a significant contribution to the common purpose, and that each of the crimes for which he was held responsible formed part of that purpose. And in cases like Krajisnik and Stanišić, the ICTY Appeals Chamber rejected similar arguments that the only way to further the plan was contributing to the crimes. Those judgments confirm that contributions to the plan do not need to involve the actus reus of a crime and do not need to be criminal per se. Contributions that advance the plan more generally, they also count. And the Appeals Chamber has also repeatedly confirmed that joint criminal enterprise responsibility is consistent with the principle of culpability. And I would refer you, for example, to the Tadić Appeals Judgment, the Martic Appeals Judgment, and the Berjanin Appeals Judgment. It is both just and fair to hold a person criminally responsible for a crime committed pursuant to a criminal plan that they shared and to which they contributed, even if an accused didn't cause a specific criminal incident. So even if an accused didn't cause the crime in the sense of participating directly in the actus reus of a criminal incident, their shared intent and contribution to the criminal plan is a sufficiently culpable link to each of the crimes committed in furtherance of it. The slide can go off. And this brings me to a convenient point to address Your Honor's questions with regard to Western SREM. I'm going to take those first, and again, I'll be returning to the aiding and abetting aspects later. We can put this slide up. I'm going to ask for a slide that just has the question on it for the public. At the outset, I'd like to state that the prosecution's position, which I'm going to explain in a bit more detail in question C, is that the unit was directly involved in persecutory displacement crimes. But I'm going to take the answers in turn with this position as the backdrop. Starting with question A. The answer to question A is yes. The prosecution is arguing that the trial chamber erred in law by restricting its contribution analysis to whether unit members were involved in the commission of charged criminal incidents. The chamber's treatment of Western SREM is a good example of the ground 1A1 legal error that I've just described. It shows how the Chamber's narrow focus on criminal incidents caused it to overlook the importance and impact of Stanišić and Simatović's contribution to the criminal plan. And as I will explain further in response to the later questions, the error is both at paragraph 162, when the Chamber finds that the unit members were not proven to be involved in the charged crimes, and also when the Chamber excludes this conduct from the JCE contribution analysis on this basis. Had the Chamber applied the correct test, it would have seen that Stanišić and Simatović's contributions through the unit in Western SREM furthered the criminal plan. And Your Honors, this brings me to question B. We can move to the next slide. The answer to question B is that the prosecution was not obligated to prove that unit members committed specific crimes in Western SREM in order for Stanišić and Simatović to incur JCE liability. The test for a contribution is whether it furthers the criminal plan, and the conduct need not be criminal in and of itself. It is therefore sufficient to show that their participation in the Western SREM ethnic cleansing operation contributed to the criminal plan by adding resources to the JNA-led efforts to cleanse the area of non-Serbs. And this remains true even if the conduct of the unit was not criminal per se when looked at in the abstract outside of the criminal context of the operation. And I'd like to emphasize, because of the wording of the question, that this conduct alone need not amount to a significant contribution, because significance is measured in relation to all of the contributions taken together, not individually. And the relevant case law for this is cited at paragraph 57 of our appeals brief. Your Honors, to answer question C, and we can move to the C slide, the evidence eliminates all reasonable doubt that Stanišić and Simatović engaged in conduct in Western SREM that contributed to the criminal plan. When properly considered in context, the evidence shows that Stanišić and Simatović and their unit members were participating in concert with the JNA and other Serb forces in the crimes of persecution, deportation, and forcible transfer. I'd like to point Your Honors to 3 areas of findings and evidence. First, the criminal ethnic cleansing context, because the context is key to understanding these events. Second, the nature and timing of the unit's activities. And third, the evidence of Stanišić and Simatović's role. Your Honors, to stay out of closed session, I am going to refer to citations in the briefs and judgments instead of the confidential evidence. But for your convenience, I'm going to put on some more detailed citations in the confidential presentation slides, and I would ask that these slides not be shown to the public. Starting with the criminal context. Not yet. No, not yet. Yeah. Starting with the criminal context. Here I'll be referring generally to the findings and evidence referred to in paragraphs 159 to 170 and 312 of the trial judgment, which make clear that this was overall an ethnic cleansing operation pursuant to the criminal plan. The Chamber found, I'd like to refer there also to trial judgment 378 and 379. The chamber found that from August and into the autumn of 1991, Serb forces cleansed the largely Croat towns and villages of Western Srem, including the villages of Babska and Sharingrad, which were just a few kilometers from Ilok. And the chamber acknowledged that international observers detected at the time a clear pattern aimed at forcibly displacing as many Croats as possible. That's paragraph 162. The Serb forces pushed non-Serb civilians who fled Babska and Sharingrad and the other neighboring villages towards Ilok, until Ilok swelled to more than double its population. But Ilok was not a safe haven for long. Serb forces were shelling and shooting there too, and the JNA issued yet another ultimatum, cutting electricity and humanitarian supplies. The chamber found that residents and refugees had no genuine choice. They were forced again to abandon everything because they faced constant fear, including from their knowledge of the brutal crimes that were committed in the neighboring villages and the sounds of Serb forces attacking all around. On 17th of October, 8,000 mostly Croat refugees fled Ilok and Serbs began to move into the homes. Your Honors, this was the criminal ethnic cleansing context into which Stanišić and Simatović deployed their unit. And this is what makes the difference. It is not the prosecution's position that every military operation or every Serb military operation during the time period of the joint criminal enterprise is necessarily an ethnic cleansing operation. But the facts show that this one, like the operation in Bosanski Shamac, was. And this brings me to my second point, about the nature and timing of the unit's participation. And Janet, here we can have the slide not to be projected to the public. The unit participated in this operation in the area of the villages of Babska and Sharingrad, on the outskirts of Ilok. Consistent with the pattern employed across the region, the JNA issued an ultimatum to both villages. The text of the 28 September 1991 Babska ultimatum is P488. It notes that despite the fact that the villagers had been peaceful and posed no threat, if they failed to surrender their weapons, then their town would cease to exist on the geographical map. And then the JNA attacked on 4th of October 1991, heavily shelling the villages and causing civilian deaths. The evidence is cited at footnote 776 of the judgment. In Exhibit P487 from October 1991, the European Commission Monitoring Mission records similarly chilling first-hand witness accounts of the violence that forced the refugees from both Babska and Sharingrad, forcing them to flee to Ilok. And Your Honors, the evidence cited in paragraph 100 of our brief shows that the unit conducted reconnaissance, swept and cleared the terrain around Babska, rooted out the remaining village defenders holding the church, and captured the Pajos Hill near Sharingrad, where they set up the unit's camp and forward command post. And in doing so, the unit's activities ensured that the Croats who had fled towards Ilok would not and could not return. As for the time frame, both of the personnel biographies that give a timing for their involvement refer to September 1991. That's P261 and P500. And according to RFJ 137, the unit conducted reconnaissance in September and entered Babska shortly after the JNA. at a time when the displaced villagers were still sheltering in Elok. And this brings me to my third point. The evidence demonstrates that both Stanišić and Simatović were personally involved in this attack. The chamber found that Stanišić and Simatović formed, trained, and deployed the elite unit, which operated under their exclusive authority. Judgment paragraphs 3A8, 405, and 407. And it's clear from the witnesses identified in paragraph 100 of the prosecution's appeals brief, including the specific references and exhibits cited there, that unit members conducted reconnaissance activities in the area and reported to Simatović, that Simatović met with senior JNA officials who briefed him on the JNA reconnaissance before the mission and agreed that the JNA would provide cover for the unit. That Simatović shared this information with the unit prior to their deployment, that the unit was deployed under the unit's local commander, Crnogorac, that the unit had direct radio communication with the JNA during the operation, and that after the operation, both Stanišić and Simatović met with the unit members to discuss the operation. And then they set up the Pajos camp and forward command post, where the chamber found that they trained more men to participate in more ethnic cleansing. And I would note here that Stanišić and Simatović can be seen celebrating the unit's operations in Western Srem in the Kula video. And again, that's P256. To conclude on this, the chamber's suggestion that the unit Stanišić and Simatović sent into these operations was only involved in legitimate military combat, unrelated to the forcible displacement that was the Serb forces' collective aim, is unrealistic, and it's inconsistent with the evidence. The unit members' conduct cannot be divorced from the nature of the operation. Instead, the trial record reflects that by participating in this ethnic cleansing operation, unit members themselves committed the charged crimes of persecution, deportation, and forcible transfer. But at the very least, there can be no reasonable doubt that their conduct contributed to the common criminal plan of forcibly removing the non-Serb population from the area. And but for the chamber's errors, these contributions would have counted. Before I move to the Sansky Most questions, I would like to briefly address a second error made by the chamber in assessing Stanišić and Simatović's JCE contributions because it's directly related to the questions. This is ground 1A3 of the prosecution's appeal. At paragraph 453 of the trial judgment, the chamber erroneously concludes that the prosecution was not pursuing charges of forced displacement in the Sansky Most operation in 1995. As the prosecution has set out in its brief, this is wrong. The prosecution maintained these charges from the initial indictment all the way through the trial and through the final trial brief and closing argument. The chamber's view appears to be based on a misinterpretation of a single sentence in paragraph 881 of the prosecution's final trial brief that refers to attacks, murders, and, quote, other crimes outlined above. The chamber interprets this as limiting the prosecution's Sansky Most forcible displacement case to the conduct set out in paragraphs 863 to 880, the paragraphs above. But the chamber overlooks that in paragraph 863, at the start of this very range that they're referring to, the prosecution indicates that Arkan's men were deployed in Sansky Most in 1995 to, quote, purge the few remaining non-Serbs. And further above that, at paragraph 654, the prosecution again argued that the 1995 Sanski Most crimes were aimed at driving out the remaining non-Serbs. So even if it had been the prosecution's intention to limit it to the things pled above, Sanski Most 1995 forcible displacement was set out above. But the Chamber also fails to appreciate that the references to maintaining control over ethnically cleansed territory in the subsequent paragraph, paragraph 882, serves to indicate that the prosecution intended to pursue the forcible displacement charges there as well. The Chamber's drastic conclusion is contradicted by the rest of the final trial brief. When properly read in context, it is clear that the prosecution did not intend, with the use of the word above, to drop the forcible displacement charges at the end of its case after having spent years consistently pleading and proving those very charges. This is not a notice issue. Both accused understood that the prosecution's case included these charges and defended against them until the very end of their cases, including addressing these arguments in their final trial briefs. Your Honors, any doubt that the Chamber might have entertained should have been resolved during the prosecution's closing argument when the senior trial attorney referred to the evidence of state security payments to Arkan's Serbian Volunteer Guard, which I will sometimes call the SDG, in connection with the 1995 Sanski Most operation, and summarized that they were, quote, in furtherance of the criminal plan to remove non-Serbs and ensure the ethnic cleansing gains previously achieved in that region. At the very least, this argument should have prompted the Chamber to ask for confirmation of the prosecution's position. And instead, the Chamber reached a conclusion that was plainly wrong and has to be corrected on appeal. And this brings me to the Sanski Most questions. And this slide, with just the question, can be projected to the public. Your Honors, the answer to question A is yes. The trial chamber erred in law at paragraph 453 by restricting its contribution analysis to whether payments from state security went to specific SDG members who participated in the commission of the September 1995 killings. This is far too narrow of a focus, and it demonstrates both of the legal errors that I've just discussed. This is another example of the Chamber's legal error in only counting contributions to specific criminal incidents. And the impact of this error is compounded by the Chamber's decision to disregard the forcible displacement charges. So only conduct that directly furthered a charged criminal incident could be counted as a contribution, and the only criminal incidents that counted were the specific charged murders. Had the Chamber not erred in both of these ways, it would have found that paying Arkan's paramilitary group across 1994 and 1995 was already a contribution to the criminal plan. Let's not forget who Arkan was. He was a JCE member who was infamous for his barbarity and the ethnic violence of his men. Supporting Arkan speaks volumes about intent, and paying the JCE tools under the command of another JCE member is in itself a JCE contribution. Question B slide, please. Your Honors, The answer to question B is also yes. Stanišić and Simatović should incur JCE liability based on the state security payments to the Serbian Volunteer Guard, even if it cannot be established that payments went to the specific members who perpetrated the crimes. And here I'm including the charged murders, as well as the SDG's many acts that amounted to the crimes of persecution, forcible transfer, and deportation, because the prosecution did not drop those charges. It's sufficient to show that Stanišić and Simatović were paying the SDG during the deployment for this operation. Their involvement in the operation still furthered the criminal plan, even if none of them can be shown to have personally committed a specific crime. Their involvement in the overall ethnic cleansing purpose of the operation furthered the criminal plan. And Your Honors, I would remind you that this operation in Sanski Most was part of a larger operation in the ARC region as a whole that was aimed at driving out remaining non-Serbs, amongst other goals. And unit members Bozovic and Filipovic were sent in to coordinate that operation and were also on state security pay lists at that time. And I'd refer you for this to the evidence cited in the prosecution appeals brief, paragraph 38, at the third bullet point. And in any event, as I'll discuss in more detail in a moment, the evidence demonstrated that the SDG unit in Sanski Most was, as a whole, paid by state security. All of the specific members who perpetrated the crimes were paid, even if we do not know their names. Your Honors, it would have been ideal to have evidence of the names of specific SDG members who pulled the trigger for the Cecina and Ternova massacres, or the specific SDG members who arrested or beat or raped particular victims. But it is simply unrealistic and contrary to the interests of justice to require such a standard when establishing the individual criminal responsibility of high-level accused. This is not a case against a direct perpetrator. And the case law says that in a case of this nature, involving multiple JCE members using tools to commit crimes, it is sufficient to identify the perpetrator by group. And this is clear from the Caramera appeals judgment, paragraph 605, and from the application of this principle by the appeals chamber in the cases cited at prosecution response brief, footnote 394. And this brings me to question C. We can show the slide for a moment. And the next slide is the confidential slide with citations to the evidence. The evidence of payments to the SDG eliminates all reasonable doubt that they engaged in conduct supporting the criminal plan. And I'm going to address 3 areas of evidence before turning to the impact of these payments. I'm going to start with the evidence of the SDG's involvement in the crimes in Sanski Most, then evidence of state security payments to the SDG in Sanski Most, and then briefly how these payments fit into the larger picture of state security support to JCE member Arkan's SDG. First, the evidence proves that Arkan's paramilitaries committed crimes in Sanski Most. Charged murders, the chamber found that they massacred non-Serbs at Sasina and Ternova. The persecutory violence, including illegal detentions, beatings, and killings, forcibly displacing the remaining non-Serbs. And the chamber acknowledged that SDG members were involved in persecutory violence beyond these murders, including evidence of rape and other killings. And Your Honors, the mere presence of Arkan's men contributed to the course of conditions displacing the remaining non-Serbs. And I would refer you to the evidence, for example, Exhibit 2D160. Given the scale and well-organized nature of these crimes, particularly the detention and the murder operations, all of the SDG members in the Sansky Most operation would have been involved in either a direct or a supporting role. These were not opportunistic crimes committed by individual SDG members gone rogue. These crimes were entirely consistent with what the SDG had been doing for years, which is precisely why their arrival terrified the population. And I remind you that JCE member Arkan was personally present overseeing this operation. The second area of evidence concerns the payments from state security to the SDG in relation to the Sansky Most operation. At paragraph 453, the trial chamber acknowledged evidence that state security paid SDG members operating in Sansky Most, including several named members who were identified as perpetrating violence against non-Serbs. The trial record includes detailed evidence of payments connected to the 1995 Sansky Most operation. In addition to the confidential testimony of RFJ 088, I would also refer to confidential exhibits P826, P541, and P543. These are pay lists from September and October 1995, which confirm that the SDG were paid regularly by the state security during the time of the Sansky Most operation. This is my third point. This evidence fits into the larger picture of state security financing paramilitaries, particularly the SDG. Mutually corroborating witness and documentary evidence demonstrates that Stanišić and Simatović bankrolled the SDG before, during, and after the Sansky Most operation. At paragraph 348, the trial chamber rejected Stanisić's argument that it was not within his remit to approve who was paid. And the evidence shows that Simatović signed pay lists throughout 1995. And witness evidence about how the payments were being made demonstrates that units were paid as a whole. And I would refer your honors to the witness evidence cited in footnote 186 and the evidence cited as an also in footnote 238 of our appeals brief. There is no suggestion in the evidence that the state security singled out individuals to receive payments during a deployment while excluding the rest of their unit. The pay lists obtained by the national authorities long after many of these witnesses had given statements corroborate the witnesses' accounts. And your honors can see for yourselves how the witness and the pay list information matches up. For example, the two SDG members referred to in your question testified about being involved in the 1994 and 1995 operations. Their names appear on the payment lists at the time of the operations, and the witnesses confirmed that they received money at the relevant times. For example, confidential exhibits P1128 and P2649, pages 16 to 22. Other SDG members participating in the same operations are on the same pay lists. And you can see this from the last part of footnote 239 of our appeals brief relating to the SDG witnesses. In addition to the pay lists, the evidence shows that Serbian state security also covered most of the SDG's costs, as well as compensation for wounding and unemployment, plus health insurance from the MUP of Serbia. This evidence is in footnotes 186 and 241 of our appeals brief, and I would also mention Exhibit 2D160. Your Honors, For the transcript record, I would like to refer you to the following information from confidential exhibits. P2304, pages 127 to 131, and 216 to 221. P2307, page 10, P2309, page 1, and P2310, page 37. I will now address the impact of Stanišić and Simatović's financial support on the charged crimes. This impact cannot be overstated. The STG was a paramilitary unit of paid mercenaries under the direct control of JCE member Arkan. State security financing made possible by Stanišić and Simatović enabled the STG to recruit and deploy in large numbers, which was critical to the success of the criminal campaign. The evidence of state security financial support to the SDG through the Sanski Most operation in 1995, during which they brutally persecuted, murdered, and forcibly displaced the remaining non-Serbs, eliminates all reasonable doubt that Stanišić and Simatović's conduct furthered the common criminal plan. But as a result of the Chamber's errors in assessing JCE contributions, this conduct was not counted. Now I'd like to turn to aiding and abetting. This is ground 2 of the prosecution's appeal. Again, the Chamber erred. It found that Stanišić and Simatović knowingly made a substantial contribution to the crimes committed by Serb forces in Bosanski Šamac. But then it overlooked all of the other ways they aided and abetted proven crimes in other places. And in doing so, it failed to adjudicate the case. The summary sentence in judgment paragraph 608, where the Chamber baldly states that the prosecution has failed to prove planning, ordering, or aiding and abetting any other crime charged in the indictment, is not adjudication. It is not a reasoned opinion. It is impossible to determine on what basis the trial chamber reached this conclusion. And there is no indication that the trial chamber ever turned its mind to any alternative modes for crimes other than those committed in Bosanski Šamac. Instead, Your Honors, it is clear that the Chamber limited its examination of alternative modes to the single instance where it found a JCE contribution. Today, I'd like to focus on 2 examples of this error concerning pre-JCE conduct and unit members' involvement in crimes. There are further examples in our briefs. Your Honors, the trial chamber's treatment of pre-JCE conduct illustrates this error. Recall that the Chamber found that the common criminal plan was formed by at least August 1991. When assessing Stanišić and Simatović's pre-August assistance in SAO-SBWS, the Chamber found that in addition to advising Hadzic, there was evidence that Stanišić may have provided weapons to SAO-SBWS in the first half of 1991. But in paragraph 537, the Chamber explicitly disregards this evidence in its JCE analysis because it predates the plan. This is correct for JCE liability. Conduct before the plan can demonstrate intent, but cannot be counted as a contribution. But the Chamber erred in not returning to this evidence to assess whether this support aided and abetted the crimes. And had the Chamber turned its mind to aiding and abetting beyond the Bosanski Šamac crimes, it would have necessarily had to make factual findings. That it did not, that those findings are absent from the judgment, proves that the Chamber did not adjudicate all the relevant conduct under all of the charged modes. And the chamber made similar errors in relation to the accused pre-JCE assistants in the SAO Ukraina. Turning to my second example, the chamber never looked at any of the other proven criminal incidents to determine whether the accused assisted those crimes. Even when it found that unit members were involved, it never asked whether the accused aided and abetted. For example, when it looked at the crimes in Doughboy in the JCE part of the judgment, the chamber found it was not proven that the unit members who participated were deployed by the accused. But what's important to ground two is that the chamber never turned its mind to the other ways that Stanišić and Simatović aided and abetted the crimes in Doughboy. For example, just as training counted in Bosanski Shamats, it should also have counted in Doughboy. At the very least, it should have been considered. And in a similar way, the chamber never addressed whether payments to Arkan's men aided and abetted any of the crimes that they committed in Sansky Most. And this brings me to the aiding and abetting parts of your questions. Starting with question B. Again, the answer is yes. By paying Arkan's paramilitaries during the Sansky Most operation, Stanišić and Simatović aided and abetted the crimes, even if it is not established that they paid specific members who can be individually identified as personally perpetrating specific criminal incidents. By paying the unit that carried out the ethnic cleansing operation in Sansky Most, they had a substantial effect on the commission of those crimes. And Your Honors, as I've already explained, the prosecution's position is, first, that Stanišić and Simatović did pay the specific members who perpetrated the crimes, as shown by the witness and pay list evidence, demonstrating that the whole unit was paid for the operation. And second, that all SGG members were involved in the massive crimes in Sansky Most, directly, indirectly, and through their intimidating armed presence in the area. Requiring a direct link from Stanišić and Simatović to a named person identified as a murderer goes far beyond the legal standard for aiding and abetting. And to answer question C, for these same reasons and the evidence I've already discussed in relation to JCE, the evidence proves beyond a reasonable doubt that Stanišić and Simatović paid the STG during the Sansky Most operations and that their conduct had a substantial effect on the commission of the crimes. These payments compensated the SGG members for their participation in arresting, detaining, abusing, raping, and murdering non-Serbs in Sansky Most, while encouraging and enabling them to continue. I'll move now to the aiding and abetting questions for Western SREM. The answer to B is also yes. Stanišić and Simatović aided and abetted the crimes in Western SREM, even if it is not proven beyond reasonable doubt that unit members personally committed specific criminal incidents there. As I stated earlier in response to the JCE part of my questions, the unit was involved in a number of activities contributing to the ethnic cleansing, including pre-operation reconnaissance, pushing out remaining defenders, clearing the terrain, securing the area, and setting up a forward command post. The prosecution's overarching position is that this conduct amounted to directly participating in the crimes, but to specifically respond to question B, at the very least, their participation substantially assisted the principal perpetrators. And similarly, in answer to question C, the evidence I've discussed shows that unit members made a substantial contribution to the charged crimes by forming and training and deploying their elite unit. Stanišić and Simatović aided and abetted the crimes. In short, by participating in the operation, Stanišić and Simatović substantially assisted the commission of the crimes of persecution and forced displacement. To summarize the error in ground 2, trial chamber did not adjudicate all of the charged modes in relation to all of the charged crimes. Justice cannot be said to be done until all of the charges have been adjudicated. I'll now turn to the final section on the errors of law and fact in assessing shared intent for JCE. This is ground 1B. Having found that Stanišić and Simatović made at least one JCE contribution, the chamber assessed whether they shared the intent to further the common criminal plan. And here again, the chamber applied the law incorrectly. Instead of looking at whether the totality of the evidence proved shared intent beyond reasonable doubt, the chamber looked at individual pieces of evidence in isolation. In each instance, it found that this evidence alone could not prove shared intent beyond a reasonable doubt. This approach is fundamentally flawed. The appeals chamber has repeatedly confirmed that the beyond reasonable doubt standard, which includes the only reasonable inference caution, only applies to assessments made on the totality of the evidence. And I would refer you, for example, to Popovich Appeals Judgment, para 1103. At the very end of its shared intent analysis, the chamber claimed that it based its decision on the entirety of the evidence. But this cannot be. There is no showing that the chamber ever considered the evidence together. Instead, there are repeated indications that the chamber misapplied the standard to evidence in isolation. The chamber never gives any explanation why potentially alternative inferences that remained after looking at a single piece of evidence could still exist even after looking at the totality. So for example, when the chamber looks at the evidence of support to Krajina Serbs before the JCE, it found at paragraph 579 that this evidence is not conclusive of shared intent. Shared intent was one inference, but there was another possibility. But the chamber never considers whether the inference, the alternative inference that still remained, was still available in light of what Stanišić and Simatović did and said over the next 4 years, including deliberately contributing to ethnic cleansing in Bosanski Shamac. The same thing happened when the chamber looked at P2790, which is the 22 January 92 intercepted private conversation between Stanišić and Karadzic, where they commented that the Croats were in for 30 years of torture and killings, and Stanišić threatens, "We will exterminate them completely." The chamber found at paragraph 581 that these comments did not, quote, demonstrate in and of themselves, intent to further the common criminal purpose. The chamber found that although Stanisić's comments were disconcerting, it could not exclude the possibility that the extreme language was an unfortunate choice of words. But, Your Honors, banter about discriminatory torture, killings, and extermination cannot be excused so lightly in the face of the evidence showing that Stanišić was actively supporting discriminatory torture, killings, and extermination. Even if this was the only time that the head intelligence officer was caught on tape making this kind of remark. This problem continues throughout the intent analysis. At paragraph 130 of our brief, we've set out other examples of the chamber dismissing individual items of evidence as being insufficient to prove intent at the beyond reasonable doubt level. But it doesn't matter that any individual piece of evidence cannot reach the beyond reasonable doubt level in isolation. Evidence is not to be considered alone. It does not itself have to be decisive of intent or exclude all other reasonable inferences. What matters is the weight of the evidence taken together. and the Chamber's repeated misapplication of beyond a reasonable doubt to individual pieces of evidence is a legal error. It was the Chamber's duty to weigh all of the evidence together. And I have to note here again that the Chamber failed to assess salient evidence of intent, in particular the Kula video P-256. The bottom line, Your Honors, is that the conclusion that Stanišić and Simatović substantially contributed to the Bosanski-Šamac operation without sharing the common criminal plan is fundamentally irreconcilable with the trial record. The Chamber accepted that Stanišić and Simatović knowingly and deliberately sent a group of trained ethnic cleansers into an ethnic cleansing operation. And the Chamber looked at this conduct in isolation and considered that it left open the possibility that they might be knowingly aiding and abetting the crimes without sharing intent. But when you add in the Chamber's other findings concerning their long-standing cooperation with and support to JCE members who they knew were pursuing a common plan, such as the training that they provided to countless attackers, not just in one camp, but in many camps in different regions over the course of years, and the support to notorious paramilitary groups, such as the Scorpions and Arkan's SDG, involved in executing the plan, including by paying JCE member Arkan's paramilitaries continuously for more than a year in the 1994-1995 time period, in full knowledge of their ethnic cleansing credentials, and the proven involvement of unit members in various ethnic cleansing crimes across Croatia and Bosnia, in places like Bilje Baranja and Western Srem and Doboj, which are part of the crime base, and in other ethnic cleansing operations, such as in Brčko and Eastern Bosnia, that form part of the larger pattern. And you add in the contemporaneous communications, the mutual congratulations shared between Stanišić and JCE member Martic, and the intercepted conversation with Karadzic about torture and killings and extermination, and the fact that Stanišić promoted Simatović while the crimes in Bosanski-Šamac were ongoing, and the 1997 Kula video of Stanišić and Simatović standing in front of a map, marking their training locations, and applauding the unit's victories in ethnic cleansing operations as JCE member Milosevic looked on approvingly. The evidence of shared intent becomes overwhelming. Your Honors, the evidence considered as a whole proves beyond reasonable doubt that Stanišić and Simatović did not just know about the shared intent of other JCE members. It proves that they too shared the intent to further the common criminal plan, and it proves that they were JCE members. And this concludes, Your Honors, the prosecution's submission, subject to any questions that you may have.
Thank you very much. The chamber has no questions, so we will adjourn the hearings for 15 minutes for a break, and then we will continue with Mr. Stanisić's response. Thank you.
All rise, veuillez vous lever.